One of the important cases here is the recently decided Delhi High Court decision in Tata versus Greenpeace, a case involving the popular Greenpeace game Tata versus Turtle. Tata's contention was that Greenpeace, by using the Tata name as part of its game, was effectively violating the Tata trademark. The Delhi High Court held otherwise, and while doing so applied the concept of parodies, the genuine parodies that make use of a trademark to mock a particular work, and the not so genuine ones which in fact are using the trademark as a matter of association with their own products or services in order to get visibility and probably even to confuse the consumer eventually. The court felt that Greenpeace's use was as a genuine parody here, and the value that drives this exception in favor of trademark parodies is nothing but free speech. The court felt, and it relied on some of the decisions of the South African Constitutional Court here, like Laugh It Off Promotions and so on. The court felt that no monopoly can go to the extent where when someone uses that particular trademark for an orthogonal purpose, which is to criticize that particular brand, there is a violation of the trademark itself. The trademark was purely a commercial right, a business right. It was a business signifier, and when not used by the other person as a business signifier, there was no reason to block the use of that particular mark. However, the court's views have been, one can't say diluted, but there is a fair bit of conflict as to the unanimity of judicial opinion on this particular exception. And the reason is simply because of some of the later decisions, one by the Supreme Court and another by the Delhi High Court itself. The Supreme Court decision was in Prakash Jha Productions, Bata versus Prakash Jha Productions, where there was a certain song used in a particular movie directed by Mr. Prakash Jha, where the song made reference to Bata, and the argument was that it portrayed the Bata brand in negative light. The Supreme Court interestingly passed an order which could be best classified as a sort of via media order, where the court said that the film must run a disclaimer saying that there was no intent to cause harm or injury to the reputation of the brand. This is a somewhat strange order, probably born out of pragmatic considerations largely, because it is inexplicable as to why somebody should run this disclaimer once it is found that it is only a genuine parody which is not meant to be taken as an indictment of the brand as much as a criticism of some of the extreme versions of globalization that we have today. The court went even further in the subsequent decision in Hamdard National Foundation versus Hussein Dalal, where the court basically granted an injunction when the name of the brand Roof Afsa was used in a jovial fashion. It was basically part of a joke in a blockbuster movie. And the court said that you have to basically remove the reference to that particular brand altogether, and this clearly is, in my view, an incorrect decision. It falls foul of Article 19(1)(a). It is somebody's expressive function to use brands that exist, whether it's a popular brand in the social media space like Facebook or Orkut, or something in the physical goods space. I mean, it is nothing but a humorous take on that particular brand or what it does, and there is absolutely no reason to stop that. And this is where we come to the last phase of this lecture, where we look at comparative disparagement, because here too we see that the court is in some sense trying to regulate the way in which people criticize brands. For instance, the important decision of the Calcutta High Court in HUL versus Unilever, where the court makes this distinction between portraying your brand in the best light possible and making a serious comparison between your brand and the other brand. The court says that the former is fine, but the latter is not, and that raises the question: aren't consumers entitled to know whether there are serious problems with somebody else's brand when compared to yours? If it's a misstatement, then there are already remedies in the law to address that misstatement. But what is the basis to make this distinction between portraying your goods in the best manner possible and not comparing your goods in a serious fashion with that of another? The court does not seem to have a strong conceptual answer. So, in some of these cases, it emerges that the court is not in a position to accept free speech values the way they are meant to actually function in society. The court is not willing to give them their real due. And to that extent, these decisions are problematic. Decisions such as Hamdard National Foundation versus Hussein Dalal, or HUL versus Rakit Benkisar. These decisions really have to probably be reconsidered in the light of upholding free speech values and not allowing intellectual property rights to override these very important values. So, finally, one can conclude that when it comes to copyright law, there are interesting and important doctrines which currently protect copyright law from an allegation of overriding free speech. But with trademarks, the position is still 50-50. In some respects, the court does protect free speech values, but in some other respects, the court does not. Thank you.